Hello everyone. I'm Anubhav Sharma. I'm the faculty for Public Administration and Indian Polity at Rouse IAS. And in this video, we are going to discuss a question that had come in UPSC GS2 paper this year. So the question is, who are entitled to receive free legal aid? Assess the role of National Legal Service Authority, that is NALSA, in rendering free legal aid in India. Fine. Let's first try to understand what exactly is this question about, from where the topic is coming from. The topic, of course, is coming from judiciary. In judiciary also, it essentially is talking about free legal aid. Let's try to understand about this. So students, when you look at the Constitution of India, what exactly you see? You see the fact it is written in a manner in which we essentially have tried to capture all sorts of rights. We have tried to talk about right to equality, Article 14. We have talked about right against discrimination. We have talked about right against untouchability. We have talked about right to freedom, right to liberty. We have talked about in right to freedom, about right to freedom of expression, right to profession, right to move freely all across India. Not just that, we also have Article 21 that talks about right to life. We have Article 25, 26 that talks about right to religion. What we have also done is to identify rights of minorities, rights of religious minorities, rights of lingual minorities, Article 29 and 30. So when you think about it, a lot of effort was put in order to articulate rights, fundamental rights of citizens of India in as comprehensive manner as possible. But somewhere what also happened, something got missed. That is, while we are trying to establish something called as right to equality, right against discrimination, we weren't quite able to pay attention to a simple fact that there's something called as right to access to judicial administration. Yes, we have uniform criminal code. Yes, there's going to be equality, there's going to be rule of law when it comes to all matters with the way in which state is going to treat the people. There will not be any preferential treatment. All titles has been abolished. But then access to judicial system, access to justice administration is not equal to all the people. The people who essentially are rich can afford to have some good lawyers. The people who are poor may not be able to get access to legal services, access to a good lawyer. They may not be even aware about their legal rights. In this respect, if you think about it, the scope of fundamental rights in so many ways gets limited to only those sections of the society who are aware about it, those sections of the society who can afford to get legal services. In this respect, that section which is backward, that section which are not aware about it, that section which essentially cannot afford legal services will be the people who will not be able to get equal administration of justice. In this respect, if you think about it, a country which wants to create a constitution which is socialist in its substance, in its content, the priority should be people who are of backward sections. What exactly can we do by which we can bring social justice to them? A very important component of social justice is going to be access to free legal aid services. In this respect, what we did was in 42nd constitutional amendment, we brought about Article 39A. We introduced Article 39A as a DPSP where it said that state should be creating policies, state should be creating laws by which it is able to do what? It is able to bring about free legal aid to backward sections of the society. In this respect, the question is about that is, who exactly are entitled to receive free legal aid? And we need to elaborate upon this aspect. In this regard, as I always say, a question requires an answer where you essentially are able to present a good intro, that is a good introduction. You essentially are able to effectively deal with the demand of the question, why, the body of the answer, and of course, you need to give a meaningful conclusion. With respect to this question, what exactly can be a good intro? As I've always maintained, there are multiple ways in which you can write a good intro. There is no one fixed policy. But then at the same time, it is also necessary that we keep in mind that whenever we attempt UPSC answers, your introduction is an opportunity by which you are able to bring value to your answer. You are able to give more points for the examiner to give you marks. as far as possible, our introduction should be something which is able to give more information to the examiner by which he has a reason to give you 1 more mark, 2 more marks. As such, what exactly can you talk about in the introduction? You can talk about that in India, we essentially brought about aspects of free legal aid in Indian Constitution with Article 39A. So you can talk about Article 39A. You can talk about free legal aid is something that has been identified by UN to be a human right. What else can you talk about? You certainly should talk about that in India in 1987 we essentially had passed Legal Services Act. That is, we essentially had passed that provision which essentially gave birth to NALSA, National Legal Services Authority, because what we had done, we essentially had passed this legislation with respect to what? With respect to Legal Services Authorities Act. We passed Legal Services Authorities Act in 1987, which indeed became the reason why we established NALSA. In this regard, this is one component that certainly I would recommend you should be mentioning in your introduction. Now that we have dealt with the introduction, let's talk about the body. In this respect, certainly we need to deal with the demand of the question. So let's break down the demand of the question. What exactly the question wants us to talk about? It essentially would want us to talk about, first thing, who exactly are the beneficiaries, who exactly are entitled to receive, benefit free legal aid under this law, Legal Services Authority Act, that is NALSA. In this regard, we know who exactly are the beneficiaries, people who are backward. We should be mentioning names or rather the sections of the people who are getting covered under these beneficiaries. So of course we know it includes SC/ST, it includes women, it also includes what? It also includes prisoners, it also includes people who are victims of human trafficking. What else? It also includes people who are from economic weaker sections. Every state legislature will decide what exactly is the annual income of a person who gets eligible with respect to getting free legal aid service. If at all you are earning less than a certain amount, then you are eligible to apply for free legal aid service. That means these are the beneficiaries that you should be mentioning. Of course, there are more people who essentially are beggars, people who are forced to destitution, people who essentially are transgenders. The idea is one can argue backward sections of the community are the people who require free legal aid more than anyone else. All those sections will need to be mentioned over here. I hope it is clear. Now that you have mentioned who exactly are the beneficiaries, the second thing that the question is asking is that we essentially should be analyzing, assessing the role that NALSA has done with respect to bringing free legal aid to these sections. In this regard, if we want to do an assessment, we will need to talk about the positive role and the limitations. What exactly will be the positive role? What they have done? So we know that they essentially have played a very important role with respect to access of legal services to women. In this respect, they have done a commendable job when it comes to dealing with cases of domestic violence. Students, we know domestic violence is something that we see all around us, but somewhere it is enjoying a kind of social legitimacy where it is not getting subjected to accountability, it is not getting subjected to the rule of law. In this respect, NALSA has taken some steps by which it is trying to help women with respect to fighting against domestic violence. They should not be subjected to domestic violence. One of the things that they had done was to essentially bring about an helpline 15100. So you can talk about this helpline. This helpline was actually launched at the time of COVID because during the time of COVID, it was seen cases of domestic violence had increased. People were under the lockdown and number of cases of domestic violence against women was increasing. In this regard, if you're mentioning this helpline, it is going to be good. Then what we also know that they essentially have started number of steps, that is measures with respect to free legal aid to prisoners. In this regard, when we talk about prisoners, what do we see? That they essentially have started this campaign called Hak Hamara Bhi Hai. Hak Hamara Bhi Hai is a way in which we essentially are able to identify prisoners under trials, and we are able to identify people who require free legal aid. So the reach out is being done by NALSA. What else we can mention? We also can mention about the work that they are doing with respect to alternate dispute resolution mechanisms. We know the fact that when we talk about access to justice, it is not only about the fact that it is getting limited to only few sections of the society, but then it is also about, are we able to ensure speedy justice to the people? In this aspect, when we talk about people who are poor, people who are from backward communities, it becomes very tough for them to get access to justice, not just because of the fact that it is tough for them to get a lawyer to go and fight a case, but also the procedural delays that are involved in normal justice administration system. You essentially will see that dates are being given, judicial process is undergoing, it number of years are taken in order to resolve a case. In this respect, what we have are alternate dispute resolution system like Lok Adalat. What exactly we can mention? The work that has been done by NALSA with respect to promotion of Lok Adalat, E-Lok Adalat, how exactly it is spreading awareness about alternate dispute resolution, Lok Adalat, E-Lok Adalat, how exactly it is able to convince people to essentially get justice through ADR, that is alternate dispute resolution mechanisms. These again are some things that you essentially can talk about as a part of assessment, that is positive role that NALSA has played. But then you also will need to talk about limitations. What exactly are the limitations that we see NALSA is getting subjected to? When you think about it, the first limitation that you should be talking about is that limited success of ADR. What do we see? That by and large, people haven't quite been able to gain confidence with respect to capacity of Lok Adalat, alternate dispute resolution mechanisms to bring justice to them. In fact, the success rate is considered to be less than 1%. So you can imagine, by and large, a lot of work will need to be done by which we are able to make alternate dispute resolution mechanism more successful. What else we see? What else we see is the fact that there are a lot of problems that essentially exist with respect to manpower and financial resources available to NALSA. NALSA has been asking for more financial autonomy, more money to be given to them, more human resources to be accorded to them. With respect to finance and human resources, we actually see that NALSA hasn't quite been able to get enough for by which they can be as effective as they should be. What else we see? We see the fact that with respect to Lok Adalat, there are a number of things which essentially are missing. One is, of course, awareness among people with respect to how exactly they can access Lok Adalats. Secondly, infrastructure that should be there for Lok Adalats for them to be effective. In this regard, both infrastructure and awareness is missing. People are not quite aware about their rights, their access to Lok Adalats. Apart from it, one major issue that we see in Indian legal system right now is less interest of lawyers in taking up pro bono cases. Pro bono cases. What are pro bono cases? See, the thing is, you must have seen in movies, one of the things that is very prominent is that there are some very good lawyers, very big lawyers, who are taking cases from very rich clients. But around the world, there is this culture where these big lawyers are also actively taking pro bono cases, that is, cases that they are fighting for free, and of course, for people who require access to justice. They fight cases of the poor, they fight cases of the backward sections. In India, one would want that lawyers, apart from taking cases for, of course, their commercial interest, but they should also be taking cases in a pro bono manner and fighting the cases of the people who are of backward sections. In this aspect, NALSA depends as much as on lawyers who would want to take pro bono cases for it to be successful. By and large, that culture of taking pro bono cases by big legal firms, by big time lawyers, has not quite developed in India. And this is something where we need to do something about it. That is, we essentially will need to spread sensitivity among lawyers, awareness among lawyers with respect to taking more pro bono cases. In fact, there are some recommendations by expert committees which suggest that we should also be making it mandatory for lawyers to take minimum number of pro bono cases if at all they want to take certain number of commercial cases, other cases. Be that as it may, these are the two aspects that you need to cover in your assessment. What exactly you have covered? You have covered what are the who are the beneficiaries. You have covered some of the positive role that has been played by NALSA, and you have also covered what exactly are the limitations that NALSA is getting subjected to. Now comes the last part, that is conclusion. What do we need to write? We essentially should be concluding by writing something which again is able to give more reasons for the examiner to give us marks. Dekho, there is no one way to write a good conclusion as it is for an introduction, but then writing a dry conclusion, an obvious conclusion, is meaningless. Because at the end of the day, this is not an exam where you're going to get a degree. It's an exam that you need to clear in order to get recruited. It's a competitive exam. In this aspect, a conclusion again should be something that should talk about something by which I'm able to get convinced that I should give you more marks as an examiner. In this aspect, what exactly you can talk about? You can talk about it is necessary that we take more measures with respect to free legal aid as it is connected directly with Article 14, right to equality. Rule of law is not only about the fact that law is same for everyone, but it should also be about access to justice is equal to everyone. What you can also talk about is Article 22, subclause 1. As we all know, it is a fundamental right of a person to get access to a lawyer if at all a police officer or state is arresting him, detaining him. We know it is covered as a fundamental right in Article 22, subclause 1. What exactly it says: whenever a person is being arrested, detained by police under punitive detention, the person should be allowed access to a lawyer by which he essentially can discuss what exactly is the cause of arrest. In this respect, if you think about it, one can argue it will be taken as a violation of fundamental right if a person is not able to get proper legal aid. Supreme Court, in fact, has said free legal aid is directly connected with Article 22, subclause 1. As such, what exactly can be a conclusion? You can talk about that apart from the other measures that are required by which we are able to make NALSA more effective, free legal aid more accessible to the people, it is necessary that we understand that all steps taken towards access to justice administration is a step by which we are able to protect Article 14 of the people and of course Article 22, subclause 1 of the people. This is the way in which I believe you could have done justice to the demand of the question.